Today, we are going to understand something about National Human Rights Commission, which was established by the Government of India in synchronization with the United Nations Declaration, so that the rights of the citizens are protected. The National Human Rights Commission looks into all the matters which are in the central list. This commission will explore all the possibilities of ensuring that the citizens' rights are protected and not violated at any cost. One of the classic cases wherein the National Human Rights Commission has played a significant role is the case of scavenging. The manual scavenging has become a bane of the Indian society, and this has been bleeding the society to a large extent in rural areas. The objectives of this session are to understand the importance of the National Human Rights Commission in a democratic setup. The other objective being to know how the National Human Rights Commission functions in terms of the constitution, membership and powers. The other objective being to understand how National Human Rights Commission investigates the issues arising out of the violation of the human rights of the citizens. Human rights is not an abstract or an ideal concept, but it is very much a pragmatic concept about those rights which are considered to be absolutely essential for the survival, dignified life and development of all human beings. Kautilya in Arthashastra said that the protection of life, property and dignity of praja, that is citizens, is the prime duty of the king. In Leviathan, Thomas Hobbes, who otherwise believed in absolute power of the ruler, too does not allow the king to violate the right to life of an individual. According to Locke, the state existed only to protect natural rights of individuals, that is right to life, property and liberty. Besides them, J.J. Rousseau, Montesquieu, Kant, Thomas Paine, John Stuart Mill, Jeremy Bentham, Karl Marx and John Rawls have been the protagonists of the rights that a state has to protect and maintain. Factors leading to the formation of NHRC. The history of human rights movement can be traced to the 13th century. Magna Carta 1215, the Petition of Human Rights 1628, Bill of Rights 1689, Virginia Declaration of Rights 1776, the American Declaration of Independence 1776, the French Declaration of the Rights of Man and the Citizens 1789 and the American Bill of Rights 1791 were the documents which gave human rights their initial constitutional status. Most of these documents were the result of long struggles of the people. After the First World War, world community started showing its concern for global mechanisms to protect human rights. Constitution of NHRC. On account of the internal and international pressure, the Government of India introduced the Human Rights Commission Bill in the Lok Sabha on 14th May 1992. On 28th September 1993, the President of India promulgated an ordinance, namely Protection of Human Rights Ordinance. This ordinance was replaced by the Protection of Human Rights Act 1993, which was passed by both the houses of parliament. Finally, the National Human Rights Commission NHRC was constituted under this act on 12th October 1993. This act drew its inspiration mostly from international covenants like the International Covenant on Civil and Political Rights and the International Covenant on Economic, Social and Cultural Rights, adopted by the General Assembly of the United Nations on the 16th December 1966. Even in defining human rights, the Act has mentioned about these covenants frequently. Independent status of National Human Rights Commission. Protection of Human Rights Act 1993 provides the Commission with functional autonomy as enshrined in Paris Principles. Composition of the Commission, qualifications of the members and method of appointment of the members as enshrined in the Act are such that ensures an independent functioning of the Commission. For example, the selection committee to appoint the members. The Commission consists of A. Prime Minister of India, B. Speaker of Lok Sabha, C. Home Minister, Leader of Opposition in Lok Sabha, E. Leader of Opposition in Rajya Sabha, and F. Deputy Chairman of the Council of States. The very composition of the selection committee shows that the members of the Commission must have the confidence of not only the ruling party but also the opposition also. The presence of Speaker of Lok Sabha and Deputy Chairperson of Rajya Sabha ensures the support of Parliament to these members. In addition to this, presence of 3 members from judiciary also provides further legitimacy and independence to the Commission. Security of the tenure of members. Removal of the members by the President of India on the ground of proved misconduct or incapacity, and the budget of the Commission which is passed by the Parliament. Section 32(1) and 2 are certain other features of the Act to provide independence to the Commission. The headquarters of the Commission shall be at New Delhi, and the Commission may, with the previous approval of central government, establish offices at other places in India. According to section 3(2) of the Commission shall consist of a chairperson who has been a Chief Justice of the Supreme Court, 2. One member who is or has been a judge of the Supreme Court, 3. One member who is or has been the Chief Justice of High Court, 4 and 5. 2 members to be appointed from amongst persons having knowledge of or practical experience in matters relating to human rights. 6. The chairperson of the National Commission for Minorities, the chairperson of the National Commission for the Scheduled Castes and Scheduled Tribes, and the chairperson of the Commission for Women. Besides these nominated members, there is a Secretary General who is the Chief Executive Officer of the Commission and exercises such powers and discharges such functions of the Commission as it may delegate to him. Appointment of chairperson and other members. According to section 4 of the Act, the chairperson and other members of the Commission are appointed by the President of India. Every appointment under this section is made after obtaining the recommendations of a committee consisting of the Prime Minister as chairperson of this committee. Other members are B. Speaker of Lok Sabha, C. Minister in charge of the Ministry of Home Affairs in the Government of India, Leader of the Opposition in the House of People, Leader of the Opposition in the Council of States, Deputy Chairman of the Rajya Sabha. Removal of a member of the Commission. Section 5 of the Act describes the procedures and ground for the removal of any member of the Commission, subject to the provisions of subsection 2. The chairperson or any other member of the Commission shall only be removed from his office by order of the President on the ground of proved misbehavior or incapacity, after the Supreme Court on the reference being made to it by the President has on inquiry held in accordance with the procedure prescribed in that behalf by the Supreme Court, reported that the chairperson or such other member as the case may be ought on any such ground to be removed. The President may remove the chairperson or any other member if he is adjudged and insolvent or engages during his term of office in any paid employment outside the duties of his office or is unfit to continue in office by reason of infirmity of mind or body, is of unsound mind and stands so declared by a competent court, or is convicted and sentenced to imprisonment for an offence which in the opinion of the President involves moral turpitude. Term of office of members. According to section 6 of the Protection of Human Rights Act 1993, the chairperson shall hold office for a term of 5 years from the date on which he enters upon his office or until he remains the age of 70 years, whichever is earlier. A member shall hold office for a term of 5 years from the date on which he enters upon his office and shall be eligible for reappointment for another term of 5 years, provided that no member shall hold office after he has attained the age of 70 years. Functions of the Commission. The Commission performs following functions. Section 12 of the Act. A. Inquiries into suo motu or on a petition presented to it by a victim or any person on his behalf on the violation of human rights or abatement thereof and negligence by a public servant and in the prevention of such violation. Intervenes in any proceedings involving any allegation of violation of human rights pending before a court with the approval of such court. C. Visits under intimation to the state government any jail or any other institution under the control of state government where persons are detained or lodged for purposes of treatment, reformation or protection to study the living condition of inmates and make recommendations thereon. D. Reviews the safeguards provided by under the Constitution or any law for the time being in force for the protection of human rights and recommend measures for their effective implementation. Reviews the factors including the acts of terrorism that inhibit the enjoyment of human rights and recommend appropriate remedial measures. F. Studies treatises and other international instruments on human rights and make recommendations for their effective implementation. G. Undertakes and promotes research in the field of human rights, spreads human rights literacy among various sections of society and promotes awareness of the safeguards available for the protection of these rights through publications, media, seminars and other available means. I. Encourages the efforts of non-governmental organizations and institutions working in the field of human rights. J. Such other functions as it may consider necessary for the protection of human rights. Powers relating to inquiries. Section 13 of the Act defines the powers of the Commission relating to inquiries. The Commission, while inquiring into complaints under this Act, have all the powers of civil court trying a suit under the Code of Civil Procedure 1908 and in particular in respect of the following matters, namely summoning and enforcing the attendance of a witness and examine them on oath, discovery and production of any document, then receiving evidence on affidavits, requisition of any public record or copy thereof from any court or office, issuing commissions for the examination of witnesses or documents. The Commission also has the power to require any person subject to any privilege which may be claimed by that person under any law for the time being in force to furnish information on such points or matters as in the opinion of the Commission may be useful for or relevant to the subject matter of the inquiry, and any person so required shall be deemed to be legally bound to furnish such information within the meaning of Section 176 and Section 177 of the Indian Penal Code. An officer not below the rank of a gazetted officer, specially authorized in this behalf by the Commission, may enter any building or any place where the Commission has reason to believe that any document relating to the subject matter of the enquiry may be found, and may seize any such document or take extracts or copies from their subject to the provisions of Section 100 of the Code of Criminal Procedure 1973, insofar as it may be applicable. Proceeding before the Commission is deemed to be a judicial proceeding, and the Commission is deemed to be a civil court for all the purposes of Section 195 and Chapter 26 of the Code of Criminal Procedure 1973. Investigation. According to Section 14, the Commission may, for the purpose of conducting any investigation pertaining to the inquiry, utilize services of any officer or investigation agency of the central government or any state government. The Commission may summon and enforce the attendance of any person and examine him. The Commission may demand the production of any document and may seize any public record or copy thereof from any office. Steps after inquiry. The Commission may take any of the following steps upon the completion of an inquiry held under the Section 18 of this Act, namely, where the inquiry discloses to the Commission of violation of human rights or negligence in the prevention of violation of human rights by a public servant, it may recommend to the concerned government or authority the initiation of proceedings for prosecution or such other action as the Commission may deem fit against the concerned person or persons. Approach the Supreme Court or the High Court concerned for such directions, orders or writs as that court may deem necessary. Recommends to the concerned government or authority for the grant of such immediate interim relief to the victim or the members of his family as the Commission may consider necessary, subject to the provisions of Clause 5. Provide a copy of the inquiry report to the petitioner or his representative. The Commission shall send a copy of its inquiry report together with its recommendations to the concerned government or authority, and the concerned government or authority shall, within a period of 1 month or such further time as the Commission may allow, forward its comments on the report, including the action taken or proposed to be taken thereon to the Commission. Grants by the central government. The central government, after due appropriation made by the Parliament, releases grants to the Commission. The Commission may spend such sums as it thinks fit for performing the functions under this Act. Accounts and audit. According to Section 43 of the Act, the Commission shall maintain proper accounts and other relevant records and prepare an annual statement of accounts. The accounts of the Commission shall be audited and certified by the Comptroller and Auditor General together with the audit report, and these documents will be laid before each House of Parliament. Matters not subject to jurisdiction of the Commission. The Commission shall not inquire into any matter which is pending before a State Commission or any other commission duly constituted under any law for the time being in force. The Commission or the State Commission shall not inquire into any matter after the expiry of 1 year from the date on which the act constituting violation of human rights is alleged to have been committed. The Commission will not entertain complaints which are vague, anonymous or pseudonyms, and those which are frivolous in nature. such matters which are outside the purview of the Commission, which pertain to service matters, power of central government to make rules. According to the section 40 of the Act, central government may make rules to carry out the provisions of this Act regarding the salaries and allowances and other terms and conditions of service of the members. The conditions of administrative, technical and scientific staff appointed by the Commission and the salaries and allowances of officers and other staff. The form in which the annual statement of accounts is to be prepared. But section 40 subsection 3 of the Act has also put a check on undue intervention by the government. According to this clause, any rule made by the government shall be laid before each house of the Parliament. If both houses agree in making any modification in the rule, or both houses agree that the rule should not be made, the rule shall thereafter have effect only in such modified form or be of no effect. Strengths of NHRC. The selection procedure of the members of NHRC is the main factor of its strength. The composition of the selection committee is such that it involves members of ruling as well as opposition party and both the houses of Parliament. Also, the composition of NHRC is such that it involves legislative executives, judiciary, academicians and NGOs. This gives the Commission a broad vision to deal with the issues of human rights. Financial autonomy, though limited, has provided NHRC independence of central government. The Commission is free to make its own budget and spend it according to its own planning. The draft of the proposed budget is placed before both the houses of Parliament, and after the approval of the budget, government without making any amendment has to provide finances to the Commission. The Commission has the power to conduct suo motu inquiry into the complaints of human rights violations. Easy accessibility to the Commission has made it one of the most popular organizations. The NHRC has advised government a number of times on the issues of human rights. NHRC in a true democratic fashion has worked immensely to create awareness among public on human rights issues through seminars, workshops, lectures, literature, NGOs, participation, universities, collaboration, etc. The Commission has extended its sphere from time to time. The communal rights in Gujarat, support for right to information, healthcare issues, disabled rights, HIV/AIDS patients' rights, etc. are some of the issues where NHRC has worked successfully. Shortcomings of NHRC. In spite of its strengths, the NHRC is suffering from certain weaknesses. Also, the NHRC is only an investigative and recommendatory body. It does not have power of prosecution. Though NHRC is just a beginning of a long journey that human rights have to travel in India, yet it has given a strong foundation to this journey. The chief contributions of this organization, besides other things, have been to create awareness regarding human rights in common masses and to develop trust in the system of justice and security. It would not be hyperbolic to say that NHRC is developing much needed human rights culture in India, without which no system of human rights protection and promotion can work effectively. The Government of India should take appropriate steps to strengthen the National Human Rights Commission with more statutory powers as required, and also by providing more manpower and logistic support so that it can discharge its duties and responsibilities more effectively. The issue of rights and the inclusion of the question of gender have far-reaching implications for public administration. The NHRC in India has been effective and demonstrated that human rights protection need not rely totally or entirely on the courts of law. Gradually, the National Human Rights Commission has become locus of human rights awareness at national level. It has been making efforts to sensitize the state governments on a number of issues relating to human rights, such as atrocities on minorities, scheduled castes and scheduled tribes, custodial deaths, compliance of the directives of the Commission regarding payment of compensation, disciplinary action, manual scavenging, problems of denotified nomadic tribes, eradication of child labor, etc. Besides, the state government should initiate prison reforms.